Dr. Wolff and others.
Mr. Midley Stewart.
May it please your lordships, my lady. I appear for the appellant, Dr. Wolff, with my lone junior, Ms. Chantriel. My lone friend, Mr. Van Heegen, King's Counsel, appears for respondent, claimant, Combe, with his junior, Mr. Barclay. Ms. Chantriel is attended by her pupil, Mr. Godaska, who's sitting there behind us. You may have noticed from the judgment and the order that there's been a change of representation on our side since trial, but Ms. Chantriel represented Wolff throughout, and so if and insofar as there are questions as to the conduct of the trial, I may have to ask her, but she's definitely here, and my lone friend, Mr. Van Heegen, represented Combe throughout. My lords, my lady, there is I saw from the listing a reference to the application. The application, as I understand it, is in relation to a further supplement, or a supplemental bundle which contains some EU materials. It's not something that my clients oppose. I consider it unlikely that we're going to go into it in any detail, or either side will go into it, but I think the position was it was wrong for it to be before the court without a formal application. So it's not something I propose to take further time up with if your lordship don't object to it.
I'm afraid I hadn't even really focused on it, but it's the EU and UK proceedings bundle, is it?
My lord, yes, it is, and it has within it, I mean, it's all trademark registry proceedings in the EU, and it's an up-to-date, almost, summary of where we are. I think there was a hearing in the General Court yesterday, but obviously no result from that as yet, but I'll update you on that when I come to it in my submissions.
So at any rate, nobody's objecting to it, so we can have regard to it for whatever it's worth.
Exactly, my lord.
Thank you very much.
So, my lords, my lady, this is the appeal by my clients, Dr. Wolff, against the order of Mr. Justice Johnson on the 2nd of January of this year, by which he declared that Dr. Wolff had infringed Combe's UK trademarks for the word Vagisil in respect of a range of female intimate healthcare goods by use of the sign, and indeed our registered mark, Vagisan, and he dismissed my client's application for a declaration of non-infringement in relation of the composite mark, Dr. Wolff's Vagisan. The judge refused permission to appeal and only granted a stay for a very short period, but I can show you what has been stayed and what hasn't been stayed by reference to the order, so we can see what's in issue here. Those stays that were granted were extended by Lord Justice Arnold on application for permission to appeal. So the core bundle, the order is at tab 7. And the operative provisions start on page 133, second page of the order. The injunction falls into two parts. There is at paragraph 4 an injunction in relation to dealings and use of mark Vagisan Simpliciter. You can see that there, and the acts restrained are importing into, offering for sale and so on in the UK goods under the sign Vagisan, and using the website vagisan.com to target, promote, offer or sell Vagisan infringing products to UK customers, and infringement by website use is something that will feature later in my submissions, and then use of any social media or social media accounts. And then paragraph 5 is a very similar scope, though a different website, in relation to the composite mark Dr. Wolff's Vagisan. And when one looks at paragraph 6, you see the scope of the stay. Paragraphs 5, so that's Dr. Wolff's Vagisan, 7, which is the publication order in the next paragraph, and 9, which is the delivery up provisions in relation to Dr. Wolff's Vagisan infringing products, were all stayed and are now presently stayed pending the outcome of this appeal. What was not stayed was the injunction for Vagisan and delivery up in relation to Vagisan infringing products, paragraph 8. While we're here in the order, just keep things formally correct, I can show you that one result of the trial below was there was a modification, limitation to the scope of the class of goods that two of the marks relied on by Combe, Vagisil. That can be seen at Schedule 1 on page 138. What was the revocation was for non-use. It was to limit the scope of the class of goods, and you can see the underlying portion for each of those marks was to add the words all the aforementioned goods for female intimate healthcare, just to limit it in relation to that. So, having looked at those,
can you just help me on that? The way it's been set out on page 138, the qualifying words are preceded by a comma and therefore appear to qualify the preceding expressions in each specification. And not therefore to qualify the other expressions. It would have been different if there'd been a semicolon. That's not how I read the judgment.
My lord, no. And I'm not, I don't even think it's I was going to venture into the worlds of the Oxford comma, but in fact it's straight on down punctuation. It should be a semicolon. They should qualify all of those goods before, and that the limitation was to the only use that was demonstrated, and I think this is common ground, was in relation to goods for female intimate healthcare. So all of those matters, including cosmetic powders, surprisingly, but all of those matters are to be limited rather than just the preceding clause, talcum powder for toilet use and cosmetic powders. That's my understanding of it. But my lord, I hadn't picked up on that, and it's not something that's subject to.
No, and I don't think that's controversial. My lord is quite right. It should be a semicolon, and it should be qualification for the whole class.
Right. Okay. Well, as long as that's common ground, that's what's matters.
My lord,
Thank you.
So, turning back to the judgment now, we can then see the marks in issue, just to give the context of what we feel it's about. The judgment is behind tab 5. Page 73 identifies the marks relied on, those 3 Vagisil UK marks, and the latter 2 of them, the 127 and the 93 mark, now to be limited in the way we've just discussed. And then we can see exemplified the use that is in dispute. If we turn the page, page 74 of the bundle paragraph 2, we can see exemplified the use and packaging of my client's Vagisan Simpliciter products and the date of introduction. So February 2013, the Vagisan Moist Cream, and then these other products, Vagisan Intimate Wash Lotion, Vagisan Moist Cream Cremulum, and Vagisan Protective Ointment going forward there. Now, website use is dealt with, and we can see best from the particulars of claim and how it was complained of. So if we turn forward behind tab 10, for the particulars of claim, and page 151 in the bundle, paragraph 12 sets out the infringing acts complained of, and you see at 12A, the claimants and the wider Combe companies have been in dispute with the first defendant since 2012 in respect of its attempts to register. So the disputes, as recognised here, were all about registration of the sign Vagisan, and what the claims are by the aforesaid conduct and in said dispute, the first defendant has demonstrated its intent to use the sign in the United Kingdom, in particular to trade under and by reference to the sign in respect of the goods detailed at 8 and 9 above. So there, what's complained of is a threat to use and an intention to use throughout that period, reflected in our application to register and our registration of the Vagisan mark. And then 12B, via a website at the address vagisan.com, the Vagisan website, the sign is used by the first defendant in respect of the goods detailed at 8 and 9, in particular to advertise and promote the same to UK consumers. And the Vagisan website is referred to, and we can look at it at Annex before, but what I take from this and what is important in my submission is that the use complained of included website use directed to and targeted at the United Kingdom as an individual class of use, and we saw that was also something that is the subject of an injunction. This may become more important when one looks at the judge's findings in relation to continuous use and the need for continuous use, because it's not in dispute that the websites were continuously used. And so website use has gone if continuous use is indeed a requirement of Section 48. But I get ahead of myself. So just looking at what was pleaded and complained about there, that's behind Annex 4 to the particulars of claim, which is at page 172 within the bundle, and it's in reverse chronological order. So 175 starts the earliest use, Vagisan from July 2014, and then there's evidence of, well, particularised complaint of use by website from March 2015, 2016, 2018, and 2020. Now, if we go back to the judgment, the second limb of the acts complained of and the subject of my client's counterclaim is Dr. Wolff's Vagisan. And we can see that use exemplified at page 124 under paragraph 273 of the judgment. So here we have the history set out, and I can paraphrase it. What the judge says, I've already noted above that from about September 2020, the defendants began to rebrand a range of products under the name of Dr. Wolff's Vagisan. What happened is that after these proceedings were served in January 2020, in the summer of 2020, my clients began to rebrand. The effects of that began to be seen from September 2020, but by the time of trial, it was not completed, and there were still Vagisan products on the market, and Dr. Wolff's Vagisan had not stepped into its shoes. And so there wasn't side-by-side, or not significant side-by-side, use of Dr. Wolff's Vagisan, and any evidence of actual confusion, which the judge held to have taken place, relates to the Vagisan product rather than Dr. Wolff's Vagisan. And if we are successful, and so at the moment, the position is my clients are selling Dr. Wolff's Vagisan in the United Kingdom. If successful on appeal, of course, we would be entitled to revert to Vagisan simplicity. Now, there are three, that's where we are in the context of my client's appeal. There are three separate aspects of the appeal, part of one of which requires formally permission to run, because it's a point that we didn't take below. That's the old version of Section 11 point. But my learned friend doesn't oppose that. He says it's hopeless, but he doesn't stop me from attempting to run it. The three aspects of the appeal are concern acquiescence under Section 48 of the 1994 Act. The second aspect is the defence afforded to my client by Section 11 of the 1994 Act in respect of use of their own mark, both in the present form and in the form that it was prior to the 15th of January 2019. That latter aspect only concerns financial relief. So any financial relief in relation to infringement before that point is of limited importance in that sense. And then the third aspect is we appeal in respect of our counterclaim for a declaration of non-infringement in respect of the Dr. Wolff's Vagisan composite mark. Again, that stands alone, and we say that the judge erred in his approach, and it's open to the court now to revisit it and form their own view.
It doesn't matter in the slightest, but just so as I've got the picture clear, was there a counterclaim to counterclaim in respect of Dr. Wolff's Vagisan?
I don't believe so.
In which case, how come there's an injunction?
My lord, my learned friend wishes to, I mean,
My Lord, we didn't ask formally for a counterclaim. We didn't formally make a counterclaim, but in the light of the judge's findings, we invited him to injunct, and there was no opposition for lack of pleading.
Right, so the judge proceeded as if there were a
Yes.
counterclaim to counter.
Absolutely.
Thank you.
my lord, and to be fair, I don't think that any attempt was made to dissuade him from proceeding on that basis.
No, one can understand the sense of it. I just wanted to be clear.
So, my lord, I intend to deal with those three aspects of the appeal separately. A word on timing. I've discussed matters with my learned friend, and my aim is to be, given we've a day and a half, my hard stop for submissions is, I think, 2:45 to give myself time to reply if I need to in relation to some of my learned friend's points. So I intend to address each of those aspects of the appeal separately. And I'll take you to the particular aspects of the judgment which relate to those particular aspects of the appeal at that moment in each case, rather than trying to go through the judgment as a whole. But before I get there, it's important to make a number of things clear. There are a number of issues that were before the judge below that are not appealed and not in issue. So it's not contested on this appeal in these proceedings that there was a likelihood of confusion between Vagisan, Vagisil, those simplistic marks. We don't appeal that finding, or indeed that the finding that there were instances of actual confusion. And it's not disputed on appeal, though it was below, that the goods for which Vagisan has been used are identical to those for which Vagisil has been registered. There's also no dispute on the judge's primary findings of fact, as opposed to the consequences thereof, though, as I will come to when we consider the judge's findings on use and knowledge in the context of acquiescence, the application of the correct legal test to those findings render his findings of knowledge of levels of sales as opposed to use more generally irrelevant or incomplete in key respects. So that's how I get around my learned friend's point when he says, there's a finding that there was no knowledge. So, before I turn to the individual aspects of the appeal, I would like, if I may, to introduce the relevant general background to the proceedings, principally by reference to the judgment, just to set the context of the dispute between the parties before the court. So, the parties are in direct competition in the sale of intimate feminine healthcare products in a number of jurisdictions around the world. Dr. Wolff sells its products under the marks Vagisan and Dr. Wolff's Vagisan. Combe sells as Vagisil, but also in markets such as Germany, where Combe was first to enter the market, under the mark Vionel, with similar branding. That's the device elements of it. Combe's home market is in the US, and their use started there. I think the product was launched in the 70s. And Vagisil entered the UK market in, I think, 1984. Vagisan, my client's product, was first launched in Germany in the early part of this century, the early 2000s, before any sale by Combe, as I understand it, in that jurisdiction. My clients filed their application for international trademark registration, designating the EU, in February of 2012, and it was registered with effect in the European Union from the 4th of December 2012. Now, there are other disputes between the parties concerning the validity of registrations elsewhere in the world, but these are the only infringement proceedings, as I understand it, that are on foot, and certainly were the only infringement proceedings that were on foot as at the date of the judgment. The proceedings referred to by the judge at paragraph 19 on page 76 of the judgment, putting matters in context, when he refers to it, he says that the negotiations, referring to the end of negotiations between the parties, negotiations continued until early 2015. I'll need to say more about them below. In the end, no settlement was reached, and that has resulted since 2015 in ongoing proceedings between Combe and Wolff in a number of jurisdictions, including Australia, New Zealand, Singapore, and the EU. Those are all, as I understand it, oppositions and applications to invalidate marks. There are no infringement proceedings. proceedings. Now, in Comb's home market of the US, there was an application. I think there was proceedings were brought seeking injunctive relief to restrain the use of Vagisan, but as I understand, they were dismissed on a summary basis because there was no evidence that Vagisan was in fact being used in the US. So it's really
Just the website.
it was just that. So around the world there are disputes as to the validity of these registrations, but the only infringement proceedings that have ever been brought are here. Now, Vagisan was launched in the UK in early 2014, and the judge found that the clock started from the point of view of any acquiescence claim in late January 2014, and that, for your reference, is at paragraph 178 of the judgment. After the negotiations that are referred to by the judge in paragraph 19 of the judgment, and no letter for action or draft proceedings having been sent in the UK or elsewhere, on the 2nd of December 2017, Combe began the EU IPO cancellation proceedings in respect of my client's mark. And we see that from paragraph 25 on page 77. There was a first instance decision in Combe's favour on the 11th of September 2019. That was appealed by my clients. The Board of Appeal upheld that decision on the 3rd of September 2020, and the General Court have just heard the appeal on that yesterday. The appeal is on both, as I understand it, on both substantive grounds as to the comparison, similarity between the mark and sign and likelihood of confusion, but also there is an issue as to the effect of the departure from the EU of Britain on the decision taken by the EU IP cancellation division. In that the marks relied on and in respect to which the decision was reached, it is argued, were the UK marks. There are other marks cited. I think there were some Spanish marks cited, but it was the UK marks that were dealt with. And there are proceedings on foot in other cases, notably the Basmati case and the Shopify case, where the effect of post the departure of the EU of grounds of opposition only relating to UK marks on the decision as to the validity of EU marks is being considered. There is an argument that if the only feature that would lead to the invalidity of an EU mark is a UK mark, once the UK has gone, it would be wrong for an existing EU TM to be revoked purely on the basis of a mark that is no longer part of it. There are other approaches saying, well, the relevant date of maybe the filing date, and that's when the EU mark, the UK was still part of the EU. So it's relevant at that stage, but it is a topic that is under consideration by the CJEU, and one of the arguments in this in the invalidity proceedings and appeal before the General Court in this case between our clients was the EU IPO was suggesting it should all be stayed pending the outcome of the CJEU's consideration of that. We don't know it's being stayed. So. The claim form in these proceedings was issued on the 3rd of October 2019. A letter for action threatening proceedings in this jurisdiction was sent on the 16th of January 2020, and the proceedings were served on the 31st of January, so close to the end of the period of validity of the claim form. 6 years, so service on the 31st of January, 6 years after the late January 2014, which we say starts the clock on acquiescence. As I've mentioned in my skeleton, I think paragraph 19, it's my client's view that it's clear that Combe waited until they got their first instance decision in the EU IPO in their favour before summoning up the courage to issue proceedings here. That's a matter for them to choose. But it's not just, that delay didn't just provide coup with encouragement from consideration by the EU IPO as to validity. In my submission, in doing so, they also gained a procedural advantage because they have avoided or reduced significantly the prospect of these proceedings being stayed pending the outcome of the EU IPO proceedings. Let me explain. I mean, this is in fact what they see. If we're successful on this appeal, it's what they want to happen now in the light of the outcome. They say if we're successful on our Section 48 appeal, anything, it should always stay pending the outcome of the EU IPO proceedings. Had proceedings been brought before the outcome of the EU IPO proceedings were known, then in my submission it would have been likely to have led to a case management stay pending the outcome of the EU IPO dispute. Dr. Wolff, as we did in these proceedings, would have relied on Section 11(1)(a) of the 94 Act, so relying on our own EUTM as not being liable to be declared invalid. My learned friend would then have been faced with challenging that, putting in an issue, and whether or not he counterclaimed to a counterclaim leading to an automatic stay, or whether he put it in issue and we sought a case management stay. It would be certainly possible, if not, we'd say likely, but that these proceedings would have been put on hold pending the outcome of the invalidity action. Instead, having waited for their first instance decision, what Combe do in their defence is they assert in their reply to our defence, that the EU IPO mark has been declared invalid. So they say it's been declared invalid. And my clients have not said, well, let's stay this pending the outcome of everything going on, because we say, having waited this long, we now have the benefit of our Section 48 defence. So they chose to wait to minimise the prospect of a stay. In fact, they may have got more than they bargained for, because we have not said, let's put this on hold pending the outcome of this, because we say, by waiting till after the end of the 5-year period without challenging any use in this jurisdiction, they have fallen foul of the acquiescence provisions. And so, on that basis, we certainly don't want a stay, because we think we've got a clear case on acquiescence, and so we think the claim can be dismissed. So, with that background and the context of how things came about, it brings me to Section 48. And what I'd like to do, if I may, is start with the legislation and the principles that we gain from the authorities, then consider what the trial judge said in his findings, and then go through the grounds of appeal and my learned friend's response to them. This will involve a degree of detailed analysis of the authorities, because we need to see where the judge went awry. Now, Section 48 is derived from the Trademark Directive. It's in the same form through all the various modifications of the Trademark Directive, though there is one change to the recital that purports to shed light on what Section 48 means. I'll take you to that when we get there. But before I start, I believe it's common ground as to the approach that this court should take to retained EU law, as that's set out in the Lipton and BA City Flyer case, which is in the authorities Bundle 1, tab 7. This has been expanded since the authorities bundle was first prepared. I wanted a few extra paragraphs put in just to give context to the judge's, Lord Justice Green's analysis, but it doesn't actually affect the impact of this. So, tab 7, page 62A is where Lord Justice Green starts to approaches the approach to be adopted following exit of the EU by the UK. Now, rather than go through, in that I think it's the effect is clear. deal with this relatively swiftly at his analysis of the relevance of judgments of the CJU starts at paragraph 65 on page 63, where he's referring to section 6.1. It's section 6.1 in what he has defined as the EUWA. So I think the European Union, the European Withdrawal Agreement Act 2020. Sorry, the European Union Withdrawal Act 2018. Good lord. That is his EUWA is a reference to the European Union Withdrawal Act 2018 in its amended form. That's from paragraph 55. So, referring back to that, and we can see the provisions of that relevant act that have...
Must be 13, I think.
13, yes. No.
Nope.
Oh, that's the trademarks one. 12, that's it, tab 12. So, and section 6 is at 177. 6.1, a court or tribunal is not bound by any principles laid down or any decisions made on or after exit date by the European Court and cannot refer a matter. 6.2, subject to this into sections 3 to 6, a court may have regard to anything done on or after exit day by the European Court, another EU entity, or the EU so far as it is relevant to any matter for the court or tribunal. And then subsection 3 on page 178, any question as to the validity, meaning or effect of any retained EU law is to be decided so far as that law is unmodified on or after exit day, and so far as they are relevant to it, in accordance with any retained case law and any retained general principles of EU law, and having regard, among other things, to the limits immediately before exit day of EU competences. So, Lord Justice Green's analysis of that, of paragraph 65 of the Lipton case.
Yeah, but just before you go back to that, we also need to take into account section 5, subsection 2, which becomes relevant not for purposes of section 48, but for purposes of section 11.
Yes, yes, my lord. Accordingly, the principle of supremacy of EU law continues to apply on or after exit day so far as relevant to the interpretation, disapplication, or quashing of any enactment or rule of law passed or made before exit day. And, well then, subsection 5, while we're here, of section 6, in deciding whether to depart from any retained EU case law of the Supreme Court or High Court, so it's only the Supreme Court, but must apply the same test as it would apply in deciding whether to depart from its own case law.
Well, of course, that's been modified by statutory instruments subsequently, and that power is now extended to this court, but neither side is inviting this court to exercise that power.
My lord, no. We say in unison. In summary, CJ, so if we look at what Lord Justice Green had to say, Section 6.1 is concerned with the interpretation of retained EU law, deals both with binding effects of EU law and with the non-binding persuasive effects of such law. Under the section, the English court is not bound by any principles laid down or any decisions made by the CJU on or after IP completion day. It may not refer to any matter of the CJU, but can have regard. However, in relation to previous decisions, this court is bound, subject to departing. So we have a division, if I can paraphrase the approach of Lord Justice Green. We have a division in the effect of authority from the CJU, up to, but not including, IP completion day. This court would be bound in relation to matters of interpretation of a retained EU law, such as the Trademarks Act. Afterwards, such matters are persuasive but not binding.
Yeah, and that becomes relevant in this case because we have the decision of the Court of Justice in the High-Tech case earlier this year, which is not retained EU law, not binding, but the court can have regard to it. And as I understand it, both parties are treating it as persuasive authority, although different conclusions are drawn from it.
My lord, it was ever thus. But yes, we say up to, and indeed we draw different conclusions, as would be expected, as to the effect, the binding effect of the authorities prior to that. So we look at part far,
Yeah.
and so on. So, my own friend also. So we say there are two things. So we rely on high tech as persuasive authority, but when it comes to the principles of EU law that we say remain binding because they were decided prior to IP completion day, there is one feature which I particularly rely upon, which is the distinction that has been consistently drawn in the context of EU trademark law between proceedings for the validity, concerning the validity of trademarks and infringement of trademarks. And I'll show you those when I go through, because this is it's a fundamental point that the judge failed to grasp, which is that there is a difference between invalidity proceedings and infringement proceedings. There's a difference between restraining use and seeking to invalidate marks, and that in fact contaminated his approach across the board, we say. And that distinction is it's graven on the heart, I would say, of trademark lawyers, and it stems from pre-IP completion day authority. So, although the relevant law is now the UK Act, it's imperative to start at the directive because all the relevant legal analysis addresses it, and indeed it's where our retained law comes from. The directive in its original form is at tab 33 of Authorities Bundle 2, but the relevant article and recitals are in the same form in the 2008 directive, and so it might be easier to go to tab 34 because the recitals are numbered there, which makes it easier to navigate. So, within tab 34, the relevant article is Article 9, page 518 of the bundle, top left-hand column, limitation in consequence of acquiescence. And this is wording we will become familiar with, where in a member state, the proprietor of an earlier trademark, as referred to in Article 4.2, so that's defining earlier relevant marks, has acquiesced, the word used, for a period of 5 successive years in the use of a later trademark. So there, we'll see when we look at the German authority and how my learned friend characterises matters. It may be that there is a linguistic or semantic issue that arises in the word order here, because here we say Article 42 has acquiesced for a period of 5 successive years in the use. We say that is acquiescence for 5 successive years in use. It's not, as we will see in the German proceedings, acquiesce in 5 years. Use continues for 5 years. We'll see what the German wording says. They flip it round slightly, which may give rise, when my learned friend comes to his linguistic analysis from the German authorities, there is a general thrust within the German authorities to say that use must be continuous, whereas looking at the directive, for a start, continuous is not a term that is used. It's acquiescence for a period of 5 successive years, and what is being acquiesced in.
Just so as I'm
is in
clear
use.
about what you've just said, I appreciate that there's German commentary, but are you making a point about the German language text of the directive? Because if you are, we would need to see that.
My lord, I'll see where I get to on the various different translations that come through, because I've been trying to work out why in German commentary that my learned friend relies on, and we'll see where he gets to that, because it's obviously not binding and none of it refers to authority. If there is a view linguistically that that there is a requirement for continuous use, that's not something that we say linguistically comes from the directive in the form we look at it. If we look at the certified translations that my learned friend has put forward for German law, it may arise. So I'm
a little puzzled by that, because one doesn't need a certified translation of the German language text to the directive, because it's an official language of the European Union, and it is self-proving.
My lord, yes. My lord, but it's...
The reason why I'm asking the questions, I'm sure you will appreciate, is that one of the advantages that the Court of Justice has over the national courts is that it's a multilingual court, and therefore it doesn't get distracted by linguistic niceties which only exist in one language version of a legislative text. It will take a broader view. And we know from experience that sometimes there are linguistic points that appear to English native speakers looking at the English language text which don't appear to speakers of other languages looking at other authentic texts.
My lord, yes. Where I put the point, and the highest I put the point, is in the context of my learned friend's reliance on a number of German commentaries, which seem to be purely linguistic and based on the German linguistic analysis.
Well, I can understand the point that speakers of all languages are capable of making the same mistake.
My lord, yes. I go no higher than saying I rely on the analysis of the CJU on these points and the language that they set out in the English translations of the judgments of the CJU. And as we will see, there is no reference within the CJU authorities for a need for continuous use of a mark to give rise to acquiescence. What is required to be continuous or for a period of 5 successive years is the acquiescence. And the judge and my learned friend take the position that in order for there to be acquiescence for a period of 5 years, there must be continuous use for a period of 5 years. I say that's wrong in principle. It's not
Well, you're going to come on to that later.
My lord, yes.
So just pursuing this moment longer,
Yes, sorry.
if the hypothesis is that the way in which the German commentary has approached things could be influenced by how the article is framed in German,
My lord, yes.
I would sort of guess that even without properly understanding German, we could see whether there's scope for that to be the source of the problem just by seeing the German language version, because one could at least see the word order. So is that something we could be provided with?
My lord, certainly, we can get that. But I as my Lord Justice Arnold has I think signposted, this may become a rabbit hole. It's not one I necessarily wish to dive into. I'm slightly regretting.
I mean, it may well be that the German commentary, as it's framed, doesn't depend on any linguistic difference. It depends on their interpretation of whatever.
My Lord, it may be. What I have done is in seeking to find some rationale for this, because there's an authority that they cite for this. It strikes me that there has been a conflation, certainly in the German approach and in my learned friend's approach, between the need for acquiescence in use for a period of so many years, with a requirement that there be use continuous for that period, and that continuous use has been acquiesced in.
And I quite follow the argument.
But I will get
to
on. We'll
the question of whether that might be attributable to any linguistic difference might be helped by seeing the German version.
My Lord, and it's becoming increasingly apparent to me that what it will not be helped with is by me pointing to the English translation of that, because it's
Well, it depends,
adding
doesn't
lens.
it? Because it depends on the approach taken by the translator of part of the years. Because one approach that translators often take is to say, oh, well, there's a parallel authentic English text, therefore I can simply use that.
It's possible, and so the translations that I have that I would look at in particular are those within the judgment of the CJEU when they translate the German provision. But again, it's still, that is through the lens of it's looking through a glass darkly. We're not looking at the original German, and so but I will dig out the original German and we'll provide it to you after lunch. So. Go back to where I was. So looking at this, the language of the article, in which we say, what is required is the proprietor of an earlier trademark acquiesces for 5 successive years in the use of a later trademark registered in the member state while being aware of such use. And it's although what has been, what's used referred to is continuous use, actually when one looks at the directive, it's actually 5 successive years, it's more contiguous, it's uninterrupted acquiescence is what is being considered. And the effect of that is if there has been such acquiescence, the proprietor is no longer entitled on the basis of the earlier mark either to apply for a declaration that the later trademark is invalid or to oppose the use of the later trademark in respect of the goods or services to which it has been used, unless the registration of the later trademark was applied for in bad faith. Now, leaving bad faith to one side, because it's not clear, what we see there is an important distinction between what gives rise to acquiescence, sorry, what gives rise to the limitation, which is to have acquiesced in use, and the consequences of the acquiescence, which is one is barred from either opposing use or applying for a declaration of invalidity.
And at one point, whenever it's convenient to you, it doesn't have to be now, it would be of assistance for your submissions as to what the logic is of having those 2 alternatives. We can see from the text that they are plainly distinct alternatives. The question is, what's the logic in particular for including the first of those 2 alternatives applying for a declaration of invalidity?
Well, my lord, I can address that now, in that the opposition, if one is no longer entitled to oppose the use of a later mark, then that it would be unfair and unjust for the proprietor of that later mark not to be able to protect their own use as against third parties. And this is crucial because it is as against third parties other than the proprietor. So we see in Article 9(3), in the cases referred to in paragraphs 1 and 2, and paragraph 2 is earlier rights other than an earlier trademark right, so one can, it's not a registered right. So in cases referred to in paragraphs 1 and 2, the proprietor of a later registered mark shall not be entitled to oppose the use of the earlier right, even though that right may no longer be invoked against the later trademark. And so, as a consequence of acquiescence, of failure to take action to restrain use, the proprietor of the earlier mark doesn't lose his right to restrain other people from infringing his mark. He can only not object to the later registered parties, but that later registrant is also allowed, they've got a registered mark, it's on the register, to use it as against third parties as well. But there is a standoff as between, a status quo as between the later mark and the earlier right. So one then doesn't have the later registrant turning around and saying, haha, you can't invalidate my right, I shall sue you for infringement. So it's a necessary consequence of this distinction between validity and infringement proceedings, is this tension. So that's the logic, and we will see again and again in the authorities this, the CJU has held that validity proceedings and infringement proceedings have different causes, they have different objects and different effects, and they're treated separately. It's not that they don't affect each other, in that if one loses one's registered mark, you can't sue someone on a registered mark, but they are not, they are different systems, and they are properly treated differently by the CJU, and where the judge fell into error is not to treat them differently in this case. So, and that actually brings me on to the first, before I go to the authorities on Section 48, there are two principles of EU trademark law, one of which I've referred to already. The first is this fundamental distinction between, in the trademark system, between infringement of marks and validity. On the one hand, the registration of a mark affords the proprietor the right to restrain others from use of the mark. It does not, absent a positive defence afforded by, say, Section 11 or Section 11A or Section 48, provide the right to use the mark. Removal of the registration, so invalidity, does not prevent the use of the mark registered. I mean, it may remove a defence that would otherwise be available, but it doesn't restrain the former proprietor of that mark, proprietor of that former mark, if I can put it that way, from using it on an ongoing basis. That is the domain of infringement proceedings, which is a separate system. And although there is interaction, and that you can see that there may be relations between the two systems in the trademark system, they are to be treated distinctly. So I say there are relations between them. For example, now one cannot rely on a mark for infringement purposes if it's more than 5 years old and you haven't put it to genuine use in the past 5 years. That's Section 11A of the 1994 Act, as it is now. And one cannot rely on a mark for infringement purposes if it's been declared invalid. It's gone. You need a valid mark to assert infringement. So I'll make this good. I said that the CJU have approached this. The FCI case is relied on by my learned friend in relation to my Section 11 appeal. But it's, we can look at it now because it addresses, in the context of a question that was whether, a question referred as to whether or not ownership of a community trademark provided a defence to infringement claim brought by an earlier the proprietor of an earlier mark. In the context of that, it makes clear this separation between the two systems. So FCI, that is, it's the second bundle of authorities, tab 21. So it's the first authority in the tab. So it's the Fédération Sinologique Internationale. We can look at this just to give some context to the facts. Within the head note, look at page 326, you can see the marks in question. The one at the top of the page is the earlier mark that have been from the Fédération Sinologique Internationale set up in 1911. The later mark from the Fédération Canina Internationale, FCI, extraordinarily close, very similar. You can see how the dispute arose. It is the one next down on the page, and they had a series of marks they were using. The question referred can be seen at AG 14 within this, just to give context. It's on page 333. What was asked was in proceedings for infringement of the exclusive right conferred by a community trademark, so that's the earlier mark, does the right to prevent the use thereof by third parties in course of trade provided by Article 9.1, so that's the infringement proceedings of provisions of community trademark regulation, extend to any third party who uses the sign that involves a likelihood of confusion, or, on the contrary, is the third party who uses that sign, which has been registered in his name as a community trademark, excluded until such time as that subsequent trademark registration has been declared invalid. So what they were asking was, if you own the later mark, do you have a defence inherently, because there is none provided by the community trademark regulation, do you have an inherent defence based on your ownership of that mark because you are not a relevant third party as defined within Article 9. I give nothing away when I say the answer is no. It was a nice try, but did not succeed. So, if we move on, you can see at, just before we move on from the Advocate General, there are a couple of points that he makes. If we turn to page 342, so AG 48, having expressed the view that the defendant was going to lose, the third party did not exclude a later registered proprietor. The AG went on to provide some other considerations of a textual and systemic nature that militate in favour of his interpretation. And so at AG 49, he's dealing with the absence of an express provision. And then at AG 50 and 51, he addresses the systemic interpretation. He says, it must next be noted that no provision of Regulation 207/2009 provides for any immunity from the prohibition laid down in Article 9.1 thereof for a third party proprietor of the later trademark, although the regulation does establish certain restrictions on the exclusive right conferred on the proprietor of a registered trademark. Particular significance attaches in that regard to Article 54. That is the equivalent of Section 48. So that's the acquiescence provision. It's clear from Article 54 that only if the conditions that it lays down are satisfied, acquiescence in use for 5 consecutive years, is there a bar to actions for invalidity and infringement against the proprietor of another later community trademark. It may therefore be inferred, a contrario, that if those conditions are not satisfied, the proprietor of the earlier trademark may indeed bring an action for infringement. So they've got the acquiescence provisions in mind. The AG has the acquiescence provisions in mind. He then goes on at AG 51 to say Article 54 is moreover relevant in that connection in the terms of the systemic interpretation of the regulation. It is in fact possible to infer from the distinction which Article 54 draws between an application for a declaration of invalidity of the later mark and opposition to the use of that trademark that Regulation 207/209, so the community trademark regulation, regards invalidity proceedings and infringement proceedings as 2 separate forms of action, for it does not stipulate that one must precede the other. And then he takes that point and he makes clear that it's more general. It doesn't just flow from Article 54. In point of fact, in the trademark sector too, as in the field of community designs, he's been analysing the community design field, there was an authority on the point. Regulation 207/209 clearly distinguishes the 2 types of action which differ in object, effect and purpose. So there's a fundamental distinction drawn, which the Advocate General highlights here, and when one turns to the judgment, you can see those comments and that reasoning are endorsed in my submission. So turn to page 352, where we have the substance of the decision of the CJU. At paragraph 32 and 33, they set up the question, but 34 is where I'd rather pick it up. Consideration should then be given to Article 54. So this is where they consider the point that the Advocate General had considered below. And at 35, they reiterate the distinction drawn by the Advocate General. Apparent from the wording of this provision that before the limitation and consequence of acquiescence takes effect, the proprietor of the community trademark is entitled both to apply to him for a declaration of invalidity of the later community trademark and to oppose its use. And then we come on at paragraphs 47 and 48.
So 35, is that sign the declaration and to oppose use?
Yes, yes, but I'm going to move on to paragraph. So having gone through the various provisions, if you look at paragraph 47, here the court addresses the distinction between invalidity and infringement proceedings. So 47, secondly, the court has already held in the context of, that's the registered design regulation, the community design regulation, that actions alleging infringement and actions for a declaration of invalidity are distinguished in terms of their object and effects, with the result that the fact it's possible for the holder of an earlier registered community design to bring infringement proceedings against the holder of a later registered community design cannot render the bringing of an application for a declaration of invalidity against the latter for OM devoid of all purpose. That finding may be applied mutatis mutandis to the context of community trademarks in such a way that the possibility for a proprietor of an earlier community trademark to bring infringement proceedings against the proprietor of a later registered community trademark cannot render either the bringing of an application for a declaration of invalidity before OHIM or the mechanisms for prime control available under the procedure for registering community trademarks devoid of all purpose. So what flows from the decision of the CJU here is an endorsement of the Advocate General's view and an iteration clearly of the distinction in community law between infringement proceedings and validity proceedings, and how infringement proceedings restrain use and the validity proceedings are to be viewed differently, separately. And that is something that flows and must be borne in mind when one considers, and this is my second general point on section 48, that the consequence of acquiescence under section 48 is twofold. One cannot oppose use of the later mark, and one cannot have the later mark declared invalid. And those are two distinct and separate consequences of acquiescence, by contrast with the condition giving rise to acquiescence, which is set out as being use alone. And so the scheme of section 48 is absolutely clear. Sorry, what becomes section 48. And it's important to distinguish the condition for acquiescence from the consequence of acquiescence. From the point of view of particular proceedings in a court or tribunal where validity is to be put in issue, the consequences of acquiescence can be avoided by bringing proceedings that would otherwise be prohibited within the time limit. So if I were in the IPO here, or in the EU IPO, and the clock were ticking on acquiescence, if I bring my application for a declaration of invalidity within the 5-year period, 4 years and 364 days of acquiescence have gone by in use, I can bring my invalidity proceedings and they are not time barred. But those proceedings do not stop the clock for acquiescence. And if I then, in some other jurisdiction, within the, so or in some other court, then attempted to restrain use or attempted to take some other step that would be barred by section 48, I'm on the wrong side of the line. And we say this is an important distinction when it comes to looking at what the judge, his reasons, and the approach he took to my client's submissions in the court below. And it's also important when considering my learned friend's points as to how EU IPO treats acquiescence claims, because he says when you bring invalidity proceedings in the EU IPO, they say, well, acquiescence has come to an end. Well, in those proceedings, it has. The clock has stopped. But it's not general. So, I'll turn now, with that introduction, to what I characterise as the 4 key cases on acquiescence that should guide this court. The first is Levi Strauss and Suchi. The second is Budvar. Those two remain binding CJU authority. Levi Strauss and Suchi doesn't say much, but it's referred to in Budvar and it gives context. And so on. The third is Lord Justice Arnold's decision in W3, his analysis, albeit obiter, but it's a useful thing, and the judge certainly was persuaded by it, so we need to have a look at what he took from what was said in that authority. And then the key, we say, capstone on these, persuasive but not binding, is the CJU's decision in Hightech. So, those are where I'm going. I'll start briefly with Levi Strauss, just to set the ball rolling. Authorities Bundle 1, tab 17. This case was, it concerned principally a relevant date for assessing the conditions for infringement and distinctive character. And as one can see from the head note, it was to do with trademarks that have been obtained for the patent sewed into a back pocket of some jeans. And the questions referred, one can see, are head note H5 on page 233. The first two are to do with timing of the determining the scope of protection. What date does one assess distinctive character and perception of the public? And then at question 4, can the position be different if the claimant's mark has lost its distinctive character wholly or in part after commencement of the unlawful use, but solely when that loss is due wholly or in part to an act or omission by the proprietor of the trademark? So what was being asked about there is, what if the proprietor of the trademark, through their act or inactivity, have allowed the mark to become less distinctive as time passes. In the context of that, the court made some observations in relation to the equivalent of section 48, so Article 9.1 of the directive. So we can pick this up at page 230, where the fourth question is considered. And so, by its fourth question, the National Court is essentially asking whether it is appropriate to order cessation of the use of the sign in question if the trademark has lost its distinctive character wholly or in part after that sign has begun to be used, and that loss is due wholly or in part to an act or omission of the proprietor of the mark. So, paragraph 27 refers to Article 5, and then Article 9.1 is referred to at paragraph 28. So thus, in Article 9.1 of the directive provides that where in a member state the proprietor of an earlier trademark has acquiesced for a period of 5 successive years in the use of a later trademark registered in that member state while being aware of such use. So again, it's all about the use and acquiescing.
Well, that's just the language of Article 9, exactly.
It is, and so on that basis, it perhaps adds nothing, but it is the language being used, and the language is in there. So I'll stop. Well, I need to read it when I see it, but I'll stop worrying about it. He is in principle no longer entitled on the basis of the earlier trademark either to apply for a declaration that it's invalid or to oppose the use of the later mark in respect of the goods or service for which it has been used. So it flags up that. And then at paragraph 29, they address the purpose of these functions. These provisions indicate the purpose of Directive 89/104 is generally to strike a balance between the interest of the proprietor of the trademark to safeguard its essential function on the one hand, and the interests of other economic operators in having signs capable of denoting their products and services. See, and so that's it. When the reference there is to Libitel, that's registration for a colour, but also it's the balance also between the proprietor of a trademark and the proprietor of a later mark as to who gets to protect their mark. So that's the rationale behind Article 9.1. And then at paragraph 30, it follows that the protection of rights that the proprietor of a trademark derives under the directive in question is not unconditional, since in order to maintain the balance between those interests, the protection is limited in particular to those cases in which the proprietor shows himself to be sufficiently vigilant by opposing the use of signs by other operators likely to infringe his mark. And then 31, the requirement of vigilant conduct is not confined to trademark protection. So we say that highlights the purpose of Article 9.1, which is to require that protection is only afforded to those who satisfy the requirement of not having stood by, acquiesced for a period of 5 years. They have to be sufficiently vigilant to protect their rights in order for them to retain the ability of protection as against that later register. To sort of use it or lose it in terms of the right in question. Now that was, the provision itself was revisited in detail in the leading case from CJU on the point, which is the Budvar decision. And that comes next. Now, with apologies to my Lord Justice Arnold, who will know the facts backwards on this case, it's important to bear in mind the facts of this case, because they were quite extraordinary, and they inform the nature of the question referred by the Court of Appeal in that case, and indeed there is, it's important, I will say, that what was considered to be acquiescence by the referring court, in this case, did not include applying for declarations of invalidity of marks. It was all about use. But we need to see that. I mean, it's got what I always think of as the sort of the day of infamy, Pearl Harbor of trademark law. There's a remarkable ambush takes place. So the facts are found at page 244. And sorry, no, I don't want to go 200. I think I want to go further. I want to take it from the judgment rather than so 272. So the facts from the judgment can be done. Paragraph 9. And one sees, look above at paragraph 5, Article 9 is set out in the familiar words that we have seen. And then paragraph 9, if I can just summarise the facts. So in paragraph 9 we get Budvar and Anheuser-Busch had entered the market in 73 and 74, and they'd each been using the word Budweiser, a word including that sign. Paragraph 10 highlights the differences between the beers, and consumers being aware of the difference, but there's some level of confusion. And then at paragraph 11, we have Budvar applying for registration of Bud, and then the real event starts at 12. 79, Anheuser-Busch and Budvar and has sued Budvar for passing off and sought an injunction to prevent Budvar from using the word Budweiser. Budvar counterclaimed for an injunction to restrain Anheuser-Busch from passing off by use of the word Budweiser. So whilst awaiting the outcome of those passing off actions, the opposition procedure relating to the registration of the word Bud was stayed. And then in 79, Anheuser-Busch applied to register Budweiser as a word. At 15, we then see that the claim and counterclaim for passing off were both dismissed, and it was held that neither could do anything to restrain each other. Bud made it onto the register at paragraph 16, and then at 17, in 1989, Budvar submitted a cross-application for the registration as a trademark of the word Budweiser, an application which Anheuser-Busch opposed. So what we have, as at paragraph 17 and around 1989, is you have two parties who have attempted to restrain each other from using the mark, but it's been held that they couldn't. But they have applied to register the marks Budweiser, each of them, in relation to the same goods. And in February 2000, they have also opposed each other's applications. So they are fighting over who is entitled to own this mark. And in February 2000, paragraph 18, the Court of Appeal dismissed both applications to registration of the word Budweiser, both oppositions to registration of the word Budweiser, and held that Budvar and Anheuser-Busch could each have that word registered as a trademark. Under the Trademarks Act 94, the court based its decision on the Trademarks Act 1938, which expressly allowed concurrent registrations of the same or confusingly similar marks in circumstances of honest concurrent use. So what has happened is there has been initial conflict about use of mark, and that conflict comes to an end as of the dismissal of the action. But the parties have applied for their marks and have opposed each other's applications. So following that judgment, each party was entered in the United Kingdom Trademark Register on the 19th of May 2000, and so Budvar, paragraph 20, acquired in the UK 2 trademark registrations, one for Bud, the other for Budweiser. Anheuser-Busch is the proprietor for Budweiser. And Anheuser-Busch has the earlier mark from 1979. And then this is the surprise attack on paragraph 21. On the 18th of May 2005, 4 years and 364 days after Budvar and Anheuser-Busch registered the Budweiser trademark, Anheuser-Busch lodged at the UK Trademark Registry an application for a declaration that Budvar's registration of the mark was invalid. So an application for a declaration of invalidity within the 5-year time period, but not, certainly not an application to restrain use.
But also, the timing was such that Budvar couldn't file counter application.
Well, that's where
By the time they knew about Anheuser-Busch's application, they were outside the 5-year window.
I don't know whether it says something bad about me, but I don't know whether to deprecate or rejoice. It has to be said, but it is as I say, I think of it as a sort of as a Pearl Harbor bolt from the blue coming in. Anyway, you can see the consequences of this. An application for declaration of validity was successful because they had made it within the
But on the face of it, it was bound to succeed,
yes,
because it was the same mark, same goods, and earlier date.
My Lord, if they hadn't, it's like an exam question. It's like an exam question. It's one of those rare but wonderful situations where but then, so Budvar appeal, and the Court of Appeal referred the questions that we see at paragraph 26. And within them, you can see at paragraph 26.1 what is meant by acquiesced. So the questions as to acquiescence, what does the word actually mean? And then questions as to what the period of 5 successive years means. When does it start from? Now, if we then turn to how the CJU considered the point, but we can move forward and go to paragraph, or the consideration of questions at paragraph 27, 28. They note that there's no definition of the concept of acquiescence, and so they have to find out what it means. And then the operative provisions that are particularly important start at paragraph 34. And we see at paragraph 37, the CJU say, acquiescence within the meaning of Article 9.1 constitutes a concept of European law, Union law, the meaning and scope of which must be identical in all member states. Accordingly, it's for the court to provide an autonomous and uniform interpretation of that concept within the EU legal order. And that meaning of acquiescence is something that obviously is binding on this court. As regards Part B of the first question, Part B being if acquiesced is a communicable concept, can the proprietor of a trademark be held to have acquiesced in a long and well-established honest use of an identical trademark by another when he has long known of that use but has been unable to prevent it? So this is when the proceedings have been dismissed in passing off. As regards Part B of the first question, the referring court observes that while the concept of acquiescence, within the meaning of Article 9.1, includes situation where the proprietor of a trademark cannot prevent the use by another of an identical trademark, in the context of the main proceedings, Anheuser-Busch and Budvar had perforce each acquiesced in the use by the other of the word sign Budweiser in the United Kingdom for more than 30 years. Now, I rely on that because...
it should be explained that the word while is inapposite translation from the French. It would be better expressed in English as if.
Oh, yes. Yes. But the point which I rely on, metaphor in particular, is the characterization by the referring court, our Court of Appeal, of acquiescence in the use for 30 years is actually in use. What is not considered by the referring court as interrupting that acquiescence, or what is referred to as disturbing that, is the application for declarations of invalidity of the mark.
There weren't any.
We went before.
Well, they opposed. Well, there were oppositions.
There were oppositions to registration. It's not the same thing.
Oh my Lord, my Lord, there had been opposition to...
Opposition is trying to stop it getting onto the register in the first place. An application for a declaration of invalidity is where it has gone onto the register and you're trying to get it off.
Well, my Lord, there had been what had not been stood by and allowed to continue without attempting to be restrained was the use of the mark. It wasn't the registration of the mark.
The use had continued because each party had failed in its attempt to stop the other.
30
That's
years
the
before.
point.
My Lord, it is the point, but the point I'm drawing is that when it comes to how the CJU respond to this, which is to say that one cannot acquiesce in use if one's not in a position to stop it, I paraphrase. So they say because perforce they had to say. They do not say, but in any event, this doesn't amount to acquiescence in use because they had opposed each other's applications to revoke or have declared invalid. It's a different, validity is different from use and infringement. And here, the parties have been forced to coexist by the failure of their passing off claims. And so they could not but acquiesce in each other's use, or could not but not oppose each other's use. But they were taking steps to oppose the registration of the marks. So in the context of validity and registration of the trademarks, there was no acquiescence. So what I'm tilting at is that the judge formed the view that one could oppose the use of a registered mark by preventing it from being a registered mark. He said, by applying to invalidate the registered mark, this was his reasoning, it is no longer a registered mark.
Shall we look at that in context?
We will look at it in time, but sorry, but I flagged this up here because the concept of acquiescence, and all the way through these authorities, it's always acquiescence in use of marks. It's not standing by while someone else gets their mark on the register, or standing by while it remains on the register. And moving on, we see where the court decided. So we go through, and the court considers the various linguistic versions. Paragraph 42, it says it must be observed that the verb acquiesce has several usual meanings in everyday language, one of these signifying allow to continue and not prevent. Acquiescence is not the same as consent, we get at paragraph 43. At paragraph 44, there's a reference as observed by the Advocate General in point 70 of her opinion, referring in particular to the Danish and Swedish language versions of Article 9. The characteristic of a person who acquiesces is that he is passive and declines to take measures open to him to remedy a situation of which he is aware and which is not necessarily as he wishes. To put it that another way, the concept of acquiescence implies that the person who acquiesces remains inactive when faced with a situation he would be in a position to oppose. I just want to pop back to paragraph 70 in the AG's opinion to see that. That's at page 256, but please keep your finger in 277. At 70, the expressions used in the various language versions all described individual conduct characterised with forbearance and non-objection in response to a situation which is not necessarily desired. A certain passivity may be identified as typical of this conduct in that the person acquiescing, although aware of the situation, declines to take countermeasures. That aspect is emphasised in particular by the Danish and Swedish language versions. This passivity contrasts with the active conduct of another person whose behaviour is actually encouraged by the inactivity of the acquiescing party. Acquiescence logically ends only when the person concerned defends himself publicly. Again, this is where we get from the AG's opinion. We have the thought that what needs to be done to draw a halt to acquiescence is in the open, in public, to defend and seek to stop the use in issue. So back to the judgment. At 277, paragraph 45, we get the conclusion. For the purposes of Article 9.1, that concept of acquiescence must therefore be interpreted as meaning that the proprietor of an earlier trademark cannot be held to have acquiesced in the long and well-established honest use of which he has long been aware, again, use we're looking at, by a third party of a later trademark which is identical with that of the proprietor, if that proprietor was not in any position to oppose that use. So it's all about restraint of use, being in a position to take steps to restrain use. So you're not acquiescing if you can't take steps to restrain, but the steps that must be taken in my submission are restraint of use. There's no mention here of invalidity. And then at 48, having gone through that, so the interpretation is supported by the context of Article 9.1, it's at 46, and then reference to the 11th recital, and then at 48, second, as stated above in paragraph 34 of this judgment, the objective of the directive is to strike a balance between the interests of the proprietor of a trademark to safeguard its essential function and the interests of other economic operators in having signs capable of denoting their goods and services. So, my Lord Justice Arnold, your question there as to what's the point of the two separate limbs under Section 48. It's to allow the other economic operators, in this case the proprietor of the later mark, to have their sign on the register and retain it and be able to use it to restrain others. That objective implies that in order to safeguard that essential function, the proprietor of an earlier trademark must be capable, in the context of application of 9.1 of that directive, of opposing, again, the use of a later trademark identical with its own. And then I'll turn over, this is a point that my learned friend relies on. And he says, it must be added that, as stated by the European Commission, the effect of any administrative action or court action initiated by the proprietor of the earlier trademark within the period prescribed in Article 9.1 is to interrupt the period of limitation in consequence of acquiescence. Now, the reference there, pause, is to administrative or court action. In my submission, in the context that we see, that's administrative or court action to restrain the use of a mark. It is a logical fallacy to say, as I understand my learned friend to do, that any kind of administrative action will do to interrupt the period of limitation. It cannot be an application for a declaration of invalidity by administrative action to interrupt the period of use, any more than, I don't know, administrative activity such as appealing a parking ticket would interrupt the use. An application for a declaration of invalidity does not interrupt use. So then what is the meaning of administrative proceedings, in a sense?
Can I just ask you this question? Does the Advocate General set out what the Commission's submission was? I mean, of course, by the time we get to this point in time, the old reports for hearing, which set out the parties' arguments, have been dispensed with, which is unfortunate but understandable. Does the Advocate General recite the Commission's submission anywhere?
I have not seen it. I'll ask my junior to check while I proceed. We can all look together, but we have the Commission says it's $49. This aspect of the Commission's submissions,
Certain submissions are recited, for example, pages 248, 247 and 248.
Yes.
But it's in quite summary form, and I haven't noticed any reference to this particular point.
We're dealing here with the first question, are we?
Yes.
So I suppose it would be most obviously paragraphs 32, 33.
Which is just, it's an autonomous concept of European law.
But I suppose 33 may add to that, but I'm not sure it adds in a very relevant way.
Yes, furthermore, Article 4.2, the early mark need not necessarily be registered before it's only acquiesced in the use of the data. Again, my Lord, I'll look, and if I find anything that sheds further light on it, I will certainly draw it to the Court's attention. There are various recitals of the Commission submissions, but not this one. But the question remains: what kind of administrative proceedings might there be that restrain use? Well, my Lord, there are many. One can consider customs proceedings, where one restrains importation. Don't go to court. You have customs proceedings. Trading standards within its jurisdiction might take steps to remove counterfeits. Perhaps even non-governmental proceedings, such as nominate proceedings to restrain use of a domain name, or to have a domain name handed back in resolution proceedings. Or indeed, though this would be something that would probably require a reference or consideration, one might consider complaints to the eBay Vero program or Amazon's matters. So I think that would stretch administrative proceedings even to those quasi-governmental bodies as those Amazon and eBay. It is not necessary.
So, I mean, could administrative action really have in mind the complaint to Amazon?
I would be surprised, but I'm not precluding arguing it at some point or later date. But certainly, I take on board that if there were no administrative proceedings that could restrain use, then my learned friend's fixation with administrative proceedings and the fact that, coincidentally, we say, EU IPO proceedings are indeed administrative proceedings, might have some legs. You see, because what my learned friend says is EU IPO refer to their own proceedings, the Board of Appeal, the CJU looking back on them refer to those as administrative proceedings, and therefore, he says, as I understand it, invalidity proceedings, which are administrative proceedings, should be enough to stop the clock. Well, not so. Not so. Just because something happens to be administrative proceedings, it has to be administrative proceedings that restrain use, such as the customs proceedings to which I refer. So, and then part C, the question, which is not in any sense disputed between the parties, but is worth thinking because one sees in various decisions and in submissions the recital of 4 factors that are required to start the period of acquiescence running. These derive from the CJU's response to Part C of the first question, which are in the following paragraphs 51 through to 59, and in particular at 53, they say it is apparent from the wording of Article 9.1 that 4 conditions must be satisfied before the period of limitation in consequence of acquiescence starts running if there is use of a later trademark which is identical with the earlier trademark or confusingly similar. So the steps are, first, there must be, the later mark must be registered. Second, paragraph 56, the application for the registration of the later trademark must have been made in good faith. It doesn't apply here, there's no allegation of bad faith. Third, the proprietor of the later trademark must use his trademark in the member state where it is registered. Again, so there must be use to start the proceeding, the timetable running. It's neutral, there's no reference there to continuous use, there's no reference to anything else. I don't think it takes matters further in terms of what nature of use is required. And fourth, the proprietor of the earlier trademark must be aware of the registration of the later trademark and of the use of that trademark after its registration. And then it's for the referring court to determine whether those 4 prerequisites, the running of the period of limitation and consequence of acquiescence, are satisfied in the main proceedings. So, but I would observe that point 3 does not impose any particular level of use. In my submission, the natural reading in the consequence of infringement proceedings is it is use capable of being restrained by infringement proceedings. So that would exclude de minimis, but if there is use that you can restrain, then in the context of the rationale behind the purpose of these provisions, if you haven't taken steps to restrain it and you were able to do so, because it's use which would be susceptible of restraint, then acquiescence exists. And as I said, there's no mention one way or the other of continuous use in that. Now, next is, and we can deal with this quite briefly, but it is important because the judge took certain comfort from it or interpreted it in a particular way, is the decision of the High Court in W3. This is tab 4 of the authorities bundle. It's an extract, and briefly speaking, I mean, this is, my learned friend was the claimants, W3 were the defendants in an infringement counterclaim. I was for Easy Group. My Lord Justice Arnold was decided the matter, and indeed the entirety of this point, as it turns out, was obiter because my client did not establish the requirements of infringement in any event. So although we persuaded the trial judge at that stage that there had been an interruption, we hadn't acquiesced, it didn't do us any good because there wasn't infringement. But what we have, and I only refer to this because the judge below considered this. My clients, in this case, had to a degree blown hot and cold. They'd sent letters for action, draft proceedings, threatened to start proceedings, and then had not begun. My learned friend's clients had brought the proceedings in issue were unjustified threats of proceedings, saying that my clients had wrongly threatened them with trademark infringement. And we see at paragraph 349 the consideration of Lord Justice Arnold at this stage. The first issue which arises is whether it's necessary for a trademark proprietor to commence proceedings of some kind in order to stop the acquiescence clock running, or whether it's sufficient to instruct solicitors to write a letter for action. Now, learned friend submission. Why I refer this in paragraph 350 is because the judge in this case, on this the judgment below in this case, but place some reliance on the first few words of paragraph 350. So counsel for W3 submitted that it was incumbent on the trademark proprietor to commence proceedings before a competent tribunal, either for infringement or for a declaration that the relevant trademark was invalidly registered. So that's my learned friend's submissions below. Simply writing letters was not enough, since otherwise a trademark proprietor could extend the 5-year period indefinitely simply by writing letters at intervals of just less than 5 years. In support of this submission, he relied on what the CJU had said in Levi Strauss at 30. And then it refers to Advocate General, I'm not even going to try, at Budvar at paragraph 70, that acquiescence logically ends only when the person concerned defends himself publicly. And then my learned friend also referred to an Italian case. Then my submissions, that's 351. I submitted the trademark proprietor who instructed us to send a letter for action and draft particulars of claim could not be said to be passive or inactive, hadn't acquiesced. We said it was all up for grabs when it came to what steps were required by way of opposing the use of a later trademark, and it's unclear what Advocate General had meant by defend himself publicly. With all of these submissions, ably put forward by my learned friend, the decision of the judge, which effectively was overturned, was that the arguments were finely balanced and it needed determination. But on balance, if he had to decide it, was of the view that the steps my client had taken were enough to interrupt the hearing. Now the question has been referred, or some question has been referred into whether those steps would have been enough, and that's in the high-tech decision. But this decision it's obiter, beautifully reasoned. I wish I'd been successful in other respects.
Is it right?
This. But well, in hindsight, looking, it is not right because it's inconsistent with the approach of high tech, and indeed it's in particular not right. Though this is not something that I believe the judge in that authority held. It's not right insofar as it's said to equate bringing in validity proceedings with something that might interrupt the period of acquiescence. It's all about use, is the drum which I bang on this appeal. So, height. Tab 31 within bundle 2. Again, it's important to have a, for the context of this decision, the facts behind the decision to be borne in mind. But we can just see, before we get to page 489, there's reference to the German law and the provision, so this is from the translation in the CJU, so paragraph 489, paragraph 12, the relevant section of the German provision is the proprietor of a trademark or trade name is not entitled to prohibit the use of a later trademark for the goods or services for which it is registered if he has knowingly tolerated the use of that trademark for a period of 5 consecutive years, unless the later trademark was applied for in bad faith. Again, this is, I mean, if
So that suggests that the language follows the recital.
Exactly. Yes, so I mean, it follows that aspect of it. I mean, what's required is knowingly tolerated the use for a substantial length of time, unless the application. It's not. It's again. It's.
But it's tolerating the use.
Yes. certainly it's but again, we go round and round.
Yeah.
The toleration is for a substantial period of time. Looking at the facts, that's paragraph 41. I'm going to call high-tech and high-tech H1 and H2 because the difference between them is a C or an H at the end of it, and I'm not capable of pronouncing it suitably. High-tech, so H1 filed their mark in 1998 with seniority claim from 1991. At paragraph 16, we see H2 being entered into the commercial register in 2003, but that's the commencement of the company. And we see at 17, H2 is the proprietor of a German figurative mark containing the word element high-tech promotion applied for on the 17th of December 2002 and registered on the 4th of February 2003, which it's used since 29th of September 2004 at the latest, and of an EU figurative mark containing the word element high-tech applied for on February 2008 and registered on 20th of November 2008, which it's used since the 6th of May at the latest. So we see there the competing rights. At paragraph 20, we see H1 sending a warning letter to H2. 22nd of April 2009, a warning letter regarding the latter's use of its trade name and the EU trademark containing the word element high-tech. In its reply of 6th of May 2009, H2 again proposed the conclusion of a coexistence agreement. So there have been some previous discussions, but that is the proposal there. And then those negotiations were not successful, did not proceed. And on the 31st of December 2012, H1 purported to initiate proceedings against H2. What follows is a series of procedural errors or failings. So we see that the fee was not paid in paragraph 22, so there's original proceedings that the advance payment had not been made and originals had not been lodged. And then we have at 23rd of September 2013, H1 informing H2 that it refused to conclude a coexistence agreement and stating it that it had initiated legal proceedings, though it had not in fact done so. It may have tried to, but it had failed. And then at 24, we have H1 informing H2 it's relying on its trade name and was the proprietor of the mark high-tech and saying legal proceedings were pending. They were not. On the 30th of December 2013, we have the court receiving written submissions from high-tech dated the 12th of December 2013 together with a cheque for court fees that they've now paid and a new application initiating proceedings bearing the date 4th of October 2013. But then in January 2014, the court draws H1's attention to the fact that it's necessary to serve the application initiating proceedings of the 15th of December 2012, and they're asked to lodge the original documents. Those originals were received on the 22nd of February 2014. 24th of February, they're not the same documents, there's an inconsistency. And then in paragraph 28, on the 16th of May 2014, the court opened the preliminary written procedure and ordered that copies drawn up by that court of the initiating application of the 15th of December 2012 be served on the defendants in the main proceedings. Notice was finally served on the 23rd of May 2014. So the 16th of May, when the preliminary written procedure was finally opened, that's more than 5 years from the initial complaint, which was back in April 2009. And it's in the context of that, and brought those proceedings, H2 defended itself and relied on acquiescence And we see at paragraph 32 that the Oberlandesgericht held that H1's action was unfounded on the ground that it was time-barred. In that regard, it noted that H2 had used its later signs for an uninterrupted period of at least 5 years. High-Tech had acquiesced in such use, since although it was aware of that use, it had not taken sufficient measures to stop that use. And that, in fact, is what had happened. And then 33.
There's an emphasis on uninterrupted use.
Exactly.
Well,
And we rely on it.
well, my lady, they record.
They record it, and you say it's just recording,
It's
but
just
it
recording,
may
but
be
it's in
that-
fact what happened. I know my learned friend relies on it and says it's uninterrupted, but in fact it was uninterrupted, and so they're just recording it.
But
It
it's
doesn't say-
irrelevant on your.
In mine, it's
analysis.
irrelevant. On my case, it's irrelevant. And 33, according to that court, the court action had not interrupted the period of limitation since it had been served on H2 and RW only after 5 years had elapsed since the warning letter which preceded that action. H1 brought an appeal before the Parliament Court. So, it's in the context of that that the questions were referred that we see at paragraph 44. And we see 44.1, can acquiescence within the meaning of 9.1 and 2 of Directive, the Trademark Directive, and 54.1 and 2 and Article 111.2 of the regulation, be excluded not only by means of an administrative or court action, but also through conduct not involving a court or administrative authority. So they're seeing whether the sending of the letter is enough. And if question 1 is answered in the affirmative, does the sending of a warning letter in which the proprietor of the earlier sign before initiating legal proceedings requires the proprietor of the later sign to agree to refrain from using the sign and to enter into an obligation to pay a contractual penalty in the event of an infringement, constitute precluding acquiescence within the meaning of Article 9.1 and 9.2. And so what they're asking is whether the period of acquiescence can be stopped by action other than bringing legal proceedings. Or an administrative. But again, so legal or administrative proceedings, but again, we would say to oppose use. And we see that characterised at paragraph 45 by its first and second questions, which it's appropriate to examine together. The referring court asks, in essence, whether Article 9 of Directive 2008/95 and so on must be interpreted as meaning that an act such as a warning letter, whereby the proprietor of an earlier mark or other earlier right opposes the use of a later mark without bringing an administrative or judicial appeal, is capable of ending acquiescence within the meaning of those provisions. So, again, we say it's all about opposing use. The Advocate General's just pausing so we can see what the Advocate General had to say on this particular point before we see the judgment. It's at tab 30, page 478, paragraph 44. This is where the AG addresses, under the heading, the need to formalise the end of the acquiescence to the infringement of rights. Paragraph 44 on page 478. So what the AG, the introduction of such action is clearly the most advanced, most formalised degree of the position to oppose, to use the language of the court. However, it's not clear from the text of paragraph 49 alone of the judgment in Budvar. So that's, one recalls, paragraph 49 is the recital of the Commission's submission that period of acquiescence would be interrupted by bringing court or administrative proceedings. That the court ruled that only the introduction of such an action can have the effect of interrupting the limitation period in consequence of acquiescence. Nor does this seem to me to be an explicit requirement. So paragraph and considers matters, if I can ask you just to, rather than reading, if I can ask you to read down to the end of paragraph 50 within this rather than reading it all to you.
Yes.
So the AG there, coming down on the side that in order to terminate acquiescence, one doesn't just have to threaten to take the measures open to put an end to infringement of rights, one actually has to take the steps.
Is it quite as clear as that? I mean, if you look at 50, only an event which unequivocally shows a clear and serious intention to assert rights, such as. The such as sort of implies there might be something else.
But, my lord, perhaps, but when one looks at where the
You
judge,
say the previous paragraph.
it's very much saying that
Take measures open to it to remedy a situation.
and one has to, and a warning letter does not provide any more guarantees as to the seriousness of the intention to assert one's rights in a binding manner. And indeed, I would also take from this, what is required is asserting rights, and we'd say to restrain, to stop the infringement, to restrain use. So, and indeed, so that's the AG's approach. If we turn back to the judgment, paragraph 47. Well, first of all, let's go to 46 on page 493. The judge, the court refer at 46 back to the decisions in Levi Strauss that we've looked at and Budvar, and the objective of striking a balance. And then at 47 on page 494, the court say, in particular, by setting a period of limitation in consequence of acquiescence of 5 consecutive years with knowledge of the use of the later trademark, so it's consecutive years of knowledge of the use, the EU legislature sought to ensure the protection conferred by an earlier trademark on its proprietor remains limited to cases where the proprietor shows itself to be sufficiently vigilant by opposing the use of signs by operators likely to infringe its mark. More specifically, as noted in recital 12, the rule on limitation and consequence of acquiescence is intended to safeguard legal certainty where the proprietor of an earlier mark or other earlier right within the meaning of Directive 2008-95, or the regulation, has knowingly acquiesced in the use of a later mark applied for in good faith for a continuous period of 5 years. Again, I'd say they're acquiescing for a period of 5 years. The proprietor of the later mark must be certain in law that such use can no longer be challenged by the proprietor of that earlier mark or other earlier right. So there is a need for certainty, otherwise that later proprietor of the mark find themselves uncertain as to whether they can continue, for example, to invest in their sign, and indeed uncertain as to whether they can restrain others. For the purposes of applying the rule, the concept of acquiescence, which has the same meaning in Directive 2008-95 and the regulation, means that the proprietor of that earlier mark or other earlier right remains inactive, even though it is aware of the use of a later mark, which it would be in a position to oppose, it acquiesced by failing to take measures open to it to remedy that situation. It follows from the foregoing that the proprietor of an earlier mark or other earlier right is time barred from seeking a declaration of invalidity or opposing the use of a later mark, applied for in good faith, so those are the two separate consequences, where for a period of 5 consecutive years, while being aware of such use, it failed to carry out an act that clearly expressed its wish to oppose that use and to remedy the alleged infringement of its rights. If we go down to through these paragraphs 51 to 53, the thrust of the court's decision is that an administrative or court action must be brought before, in order to interrupt the period of acquiescence. And at 53, by bringing such an action, the proprietor of the earlier mark or other earlier right unequivocally expresses its wish to oppose the use of the later mark and to remedy the infringement of its rights. So, from this, again, the whole thrust of the section is a requirement that steps must be taken to restrain use. That's the interruption of the acquiescence period. And then the consequence of acquiescence is that not only can one not oppose use, one cannot seek a declaration of invalidity. So I think that's probably all I...
Just for completeness, 54 onwards, you get a sort of halfway house, do you? Because the acquiescence can stop before you bring the proceedings, even on this thesis. The warning letter, which is followed by proceedings, will do.
Yeah.
But it's perfected. I mean, you're absolutely right, Lord, in that sense. But when one sees the consequence, and indeed one looks at the context of the third question, although the period of acquiescence may be interrupted before the proceedings are actually served, if the proceedings are actually served, if one doesn't bring the proceedings, serve the proceedings before the end, before 5 years has passed, then the consequence is that you have acquiesced. So you need actually to get, I mean, it's a distinction that doesn't really apply. We can see, because the point of the third question asked in high-tech was, what is the consequence of the proceedings not being served, although they were issued, through the error of the party who was applying them. I mean, the third question we see at 58, the referring court asks whether Article 9 must be interpreted to mean that the limitation and consequence of acquiescence referred to in those provisions may be prevented by the bringing of a court action which the proprietor of an earlier trademark or other earlier right seeks a declaration of invalidity or a later mark or opposes that mark, where the application initiating proceedings, though filed before the date of expiry of the period of limitation, was not, owing to a lack of diligence on the part of the applicant, served on the defendant until after that date. So they're considering whether consequences of the acquiescence, which is you can't challenge invalidity and you can't oppose the use, flow when the proceedings were issued. Although they were issued before the date of expiry of the limitation, they weren't served properly until after that date, which is actually what might have happened in the high-tech case. And you can see it's referred back to the court below and say, look, you'll have to work out whether they're stopped or not. So although paragraph 55 through to 57 suggests that there is a halfway house and you may have stopped acquiescence by sending a letter if you follow it through, the following through has to happen within the period of 5 years.
I don't know if this matters, but is that right? If you look at 55, it talks about pursuing your efforts within a reasonable period, which sort of suggests that if you send your warning letter and then you take your action within a reasonable period after that, it doesn't matter if the action comes after the end of the 5 years.
Well, my lord, if one looks at the consequence, so bearing in mind the third question, which is
Yes.
what is the result?
But they didn't do much within the reasonable period.
Well, but what's said at paragraph 67 in response to the third question is, in those circumstances, it is for the referring court to ascertain the date on which the application initiating proceedings was rectified in such a way as to enable the court seized to commence proceedings and to serve that document in the main proceedings. If the rectification did not take place until after the expiry of the period of limitation, so they're drawing a line there, in consequence of acquiescence, it is for the referring court to assess whether that fact is mainly due to the conduct on the part of the applicant in the main proceedings, which may be characterised as a lack of diligence. If that court were to take the view that was the case, it would have to conclude that due to High-Tech's lack of diligence, its action must be regarded as time barred. So there, if you don't get it within the period, unless you can say it's not my fault, not my lack of diligence, you're time barred.
But is that, I don't know that this matters in this case, but there's not of a piece. There's the idea of doing something within a reasonable period. If you do something within the reasonable period, if you are diligent, then it doesn't matter if the action comes after the end of the 5 years. If, on the other hand, it comes after the end of the 5 years because you haven't done something within a reasonable period and you haven't been diligent, then the warning letter won't of itself do.
My lord, in my submission, it's that the question is whether the conduct, whether if in order to stop the period of acquiescence, one needs to have within the period, the 5-year period, have sent your letter and brought proceedings, or issued proceedings, and then you have them served. And if they're served, and the effect is that they were served before expiry of the acquiescence period, even though, sorry, the proceedings started before the expiry of acquiescence, then that gets you home.
But in that case, you can forget about the warning letter, can't you? I mean, the warning letter is just irrelevant.
Well, my lord, that's what I find great difficulty with the warning letter. You need to follow it. If you have a warning letter, you need to follow it with bringing proceedings
Within a reasonable period.
And well, within a reasonable period, but the reasonable period must be, and I think the consequence, otherwise I don't see what the consequence of paragraph 67 is. If you don't bring your proceedings in any event within the acquiescence period, then you are precluded. So it might
But it is odd, as my lord said, that there's any reliance on the warning letter in that case. Because you just don't need it. If you've brought it within the 5-year period, it's irrelevant.
Well, my lady, it might be that if one wrote a warning letter and was dilatory and did not pursue, then even if one did provide, but even that, sorry, so even if then one did issue proceedings within the 5-year period, you could say, well, the warning letter didn't interrupt acquiescence, but if you brought your proceedings within the 5-year period, you're stopping it in any event.
But that's the
point.
puzzle, isn't it? I mean, why are they worried about the warning letter?
Yeah.
It all turns on whether or not you've initiated your proceedings within 5 years.
Well, the question, perhaps why they're focusing on it is the question referred to the warning letter, and they're considering what is the point and where do you get to with a warning letter. But the upshot, in terms of the need for certainty, is that you must take proceedings, and it's no good if one is having the purpose of the provision, section 48 or article 9, is that one knows at the end of a 5-year period that one is now free to continue to exploit. And that purpose is not satisfied if I can issue proceedings, I can write a warning letter and the 5-year period expires, and then I issue proceedings afterwards and say, well, look, I warned you about it 4 years ago. So its certainty needs to be assessed as at the end of the 5-year period from the commencement of the period of acquiescence.
Is that really a fair point? I mean, if I write my warning letter a month before the end of the 5 years, saying, you have to stop. If you don't stop, then I will, in 6 weeks' time, bring proceedings. And in 6 weeks' time, you do bring proceedings. I mean, is there any problem of certainty? You know within the 5 years that you're on notice that proceedings are liable to be brought in a couple of weeks' time.
Well, my lord, what the decision, the judgment of the CGU makes clear is that there needs to be certainty both in the starting point and the end point of the period of acquiescence. And the thrust of the decision is certainly that issuing proceedings is what affords that certainty. Now, there may be corner cases where one thinks, well, that's a bit unfair. You've written your letter, but that's not the certainty requires that clarity of interpretation. And in my submission, the answers as formulated make clear that it's the sending of a letter, that a warning letter itself does not interrupt the period of limitation. So we get that if we want to look at the answers at page 498, the response is given. Article 9 of the directive must be interpreted to mean that an act such as a warning letter by which the proprietor of an earlier mark or other earlier right opposes the use of a later mark without taking the necessary steps to obtain a legally binding solution does not stop the acquiescence, does not interrupt the period of limitation. And Article 9, next question, answer to the next question. Article 9 must be interpreted to mean that the limitation and consequence of acquiescence referred to in those provisions may not be prevented by the bringing of a court action which the proprietor of an earlier trademark or other earlier right sought a declaration of invalidity of a later mark or opposed the use of that mark, where the application initiating proceedings, although filed before the date of expiry of the period of limitation, did not, owing to a lack of diligence, satisfy the requirements for the applicable national law for service and was rectified only after that date. So it's those two answers, my submission, set out a tolerably clear regime. It may be that matters don't. It doesn't matter in the circumstance of this case, but that's certainly it's there, and we certainly say there is no support within high tech for the suggestion that it's anything other than opposing use.
Can I just ask you something
Yes,
about that? At 50, the court talks about expressing a wish to oppose rather than action to oppose use. And I just wonder whether it's contemplating the possibility of invalidity proceedings as expressing a wish to oppose. Because invalidity proceedings would be one remedy for the situation. It wouldn't prevent use, but it would express a wish to oppose, wouldn't it?
My lady, with respect, I'd say no, in that a wish to oppose use requires opposition of use, and the fundamental distinction between validity proceedings and infringement proceedings is you can knock someone else's mark off the register,
But that
but
doesn't
it
stop
doesn't
use.
stop them using. And if that is your indication of a wish to stop their use, then it's a pretty faint wish.
And you also relied upon the succeeding words and to remedy the alleged infringement of its rights.
Well, my lord, yes. There is that. There is that. I certainly accept that. So, good lord. Now, time marches on. I need to pick up my speed in that we are approaching lunch, and I have not yet turned to the judgment below. So, in the court bundle, judgment is at tab 5. Let's start at the position where the judge starts to consider the legal test at paragraph 170. So the judge sets out that we rely on the acquiescence defence. Sets out the provision, section 48.1. And at 173, principal issue between the parties whether there was in fact acquiescence by the claimants, and then refer to subsidiary points. And at 175, we see the issues as they begin. In the present case, there is no issue, referring back to the above conditions, about conditions 1 and 2. But in addition to saying they didn't in fact object to the use of the defendant's mark, claimants also said that for certain parts of the 5-year time period relied on, the defendants were not actually using their mark in any meaningful way, so that's to do with use, or if they were, the claimants were not aware of such use because it was so limited and it did not register with them. So they therefore submitted that that conditions 3 and 4 above were not fulfilled. So the key facts are then set out at 176 onward. At 180, we see where I say the first sign of the judge falling into error. So 180, no sales of Vagisan or no knowledge of sales mid-2005 to December 2006. So the claimants also say that in point of fact there was no continuous use of Vagisan by the defence for a 5-year period beginning in late January 2014. They say that at mid-2015 at the latest, Vagisan had fallen off the UK market, was not relaunched until 2016. At any rate, they say the claimants team, including in particular Ms. One, was monitoring the UK market, saw no evidence of sales, which is emphasis of Vagisan during that period, so were not aware of the defendant's use of their mark. Now, we say this is the first indication of the judge falling into error, because he's there focusing on the requirement of actual sales, of a material level of sales to constitute use, and that has led him to equate sales with infringing use, despite the fact that defendants, as we saw in the pleadings, allege use of the website as infringement, and specifically required the website to be addressed by way of injunction at trial. I'll return to this as the judge does when we get to paragraph 250 of the judgment, which is where he considers the state of knowledge issue. At 181, he refers to the invalidity action. And again, this is what we say is a major error on the part of the judge. His finding, building on this, that the issuing of the EU IPO invalidity action was sufficient to stop the period of acquiescence because it amounted to opposing use. So we say that is another error of principle. And then at 182, we do this quite briefly. This was a point subsequent to the issuing of the invalidity action. There was a call with Mr. Santini. We say not a lot turns on this because there were no infringement proceedings brought within the period. But the issue here is there was a discussion as between the parties. It arose during, it came to light during re-examination of Mr. Santini. But we say this is not enough to interrupt the period of acquiescence, and the judge was wrong to hold so insofar as he did. But in any event, given this was a without prejudice call, I'm not saying that the judge was wrong to refer to it, came out in evidence and was not objected to on that basis, but because it was a without prejudice discussion, it does not amount to a public communication for the purposes of interrupting proceedings. So, our first ground of appeal is to say the judge got it wrong insofar as he held that the bringing of an EU IPO invalidity action was sufficient to interrupt the period of acquiescence. And his analysis on that point begins at paragraph 185. Now, we can see his reference to the EU IPO invalidity claim. And then at 186, the question is whether the claimant's initiation of their invalidity action was sufficient to stop the clock running on the 5-year period. Was it, in other words, evidence of a lack of acquiescence by the claimants? he recites our argument at 1H7. We say what 48 required to stop the clock is an objection to the use, and this was not an objection to use. And that's what I've, to a degree, been banging on about through the course of this morning. The judge considered that. He then looked at these two passages from Budvar at 188. He says he defines acquiescence and adds effort. The emphasis we see. The characteristic of a person who acquiesces is that he is passive and declines to take measures which are open to him to remedy a situation of which he is aware. We say absolutely. That's what bringing infringement proceedings would do. It's not bringing validity proceedings. And then at 49, the court says, apparently with approval, it must be added that the effect of any administrative action or court action initiated by the proprietor within the period is to interrupt the period of limitation. So again, we say what he's cited there is not incorrect, but the conclusions he's drawn are not right. At 190, in light of this guidance, I am unable to accept the defendant's construction of section 48, so that's us saying that you need to object to use. His first point is a linguistic one. He says it's too narrow a reading of the first part of section 48. It's true that what is described as having a preclusive effect is acquiescence for a continuous period of 5 years in the use of a registered trademark, but it seems to me quite artificial to stress in that phrase only the word use, and to say what's needed is some step which is directed towards the preventing of use per se. So he says that it's not about stopping use. The phrase taken as a whole is the use of a registered trademark, and this is where he characterises his approach as worthy of Lewis Carroll. This is where he says the use of a registered trademark as a straightforward matter of language seems to me clear that if the owner of an earlier mark seeks to invalidate the registration of a later mark, he cannot be said to be acquiescing in the use of a registered trademark because he is saying that there has been no valid registration. Pausing there. He says that our approach to the language is artificially narrow. But the approach he is taking is ignoring, and this is his first fundamental error, ignoring that distinction between validity and infringement, which is a backbone of trademark law. And the judge, by saying that if one seeks the invalidation of a mark, one is not acquiescing in the use of a registered mark, the consequence of that is that if the registration is removed, but the use of the mark is not opposed, he is nonetheless saying that you've opposed the use of that registered mark. Now that's far from straightforward as a matter of language. Having made no opposition to any use at all, the judge says that you are nonetheless opposing use because you've removed the registration. And again, the judge's conclusion is that it is sufficient to interrupt the period of acquiescence, even though one has taken no step to restrain the act of infringement. And so we say that is inconsistent with the approach that we've seen in the authorities, and it's inconsistent with the definition that he himself had referred to in Budvar, which is remaining inactive when faced with a situation that you're in a position to oppose. Combe did not take steps to oppose the use. And so they have remained inactive. And yet the judge said it's enough by removing the registration to deal with that, it interrupts the period of acquiescence. Because what indeed Combe did, they didn't oppose the... what is required by Budvar is not the opposition to the ownership of registration of the mark, it's opposition to the use of the mark. And as we point out in our skeleton, even the premise of his argument, his analysis, which is that once one has removed the registered mark, there can be no use of a registered mark, does not necessarily flow. So assume you have a European trademark with a number of member states and invalidity is established in one member state but not all. The mark, the EUTN, could be invalidated. But the proprietor could convert all the others to national marks, would still have registered marks, would still be able to rely on them in those jurisdictions. Also, assume invalidity was successful for some goods but not others. Again, it's the way in which to oppose use in my submission that is contemplated by Butler is to do just that, to oppose use, not to seek to knock out a registration. The judge then analyses my client's position in the subparagraph, paragraph 192, and accuses or identifies or characterises my client's position as being illogical. It's worth just having a look at these. In my submission, they reveal instead, unfortunately, the illogicality of the judge's approach. So, little Roman 1, it said, my clients argue the clock stops ticking only when steps are taken to oppose the use. And applying for a declaration of invalidity is not a form of opposition to use. But yes, that's what we say. If that is right, the consequence must be that even if the proprietor of the earlier mark commences invalidity proceedings within 5 years, there's still ongoing acquiescence. Yes, that's what we say. Little Roman 3, that cannot be correct. Well, the question is, why? If one properly distinguishes between the two limbs of section 48, so the limb that identifies what constitutes acquiescence and then the consequences of acquiescence, then it is perfectly within the contemplation of the legislation that one could bring proceedings that one would otherwise be time barred from and yet not interrupt the period of acquiescence. Little Roman 4, the judge recites our submissions. We sought to suggest that no problem arose because in such a case there was no question of a proprietor of the earlier mark being precluded from pursuing the invalidity proceedings. Yes. So the issue of acquiescence did not come into play. They gave the following example, and this is A acquiesces in B's mark for 3 years and applies for a declaration of invalidity while still acquiescing in use. Another 3 years pass and A sues for infringement. The declaration of invalidity proceeds. There's no preclusion that, as there is no question of 5 years having passed, but as there's still been continuing acquiescence to use for 5+ years, A's infringement action is precluded. We say yes, that is the necessary consequence of that division between invalidity and infringement proceedings, and the distinction that is drawn in section 48 between the qualification for acquiescence, which is to stand by and not object to use, and the consequences of that, which are one cannot object to infringement or validity. And then at 5, he addresses a logical difficulty, which in my submission, I respectfully say isn't there. It seems to me this merely sidesteps the problem rather than addressing it. There's no getting around the fact that on the defendant's case, because the invalidity proceedings are not an objection to use, there is continued acquiescence for the purposes of the section as a whole, even though the proprietor of the earlier mark has commenced such proceedings. Is thus, while pursuing his invalidity proceedings, at one and the same time, nonetheless still acquiescing. It is no answer to say that does not matter, because he is already making his challenge. What is illogical is the idea that even while doing so, he is simultaneously acting in a manner which qualifies as precisely the form of acquiescence the statute deprecates. It's that basic inconsistency which is the issue. With respect, again, this flows from the failure to distinguish, the judge's misapprehension and finding the logical difficulty, flows from his failure to distinguish between that first limb of the test, what causes acquiescence, what qualifies as acquiescence, and the second limb of the test, what is the consequence of acquiescence. And so it is possible to contemplate a system where the first limb of the test was coterminous with the second limb of the test. But that's not what we have here. And the judge's problem is it's only a logical problem on his interpretation, so it's entirely circular. And then Little Roman 6, again, he's failing to distinguish between these two limbs of section 48. the proprietor of an earlier mark who seeks to invalidate a later one is objecting to the very existence of the mark on which the Section 48 is based. If he is successful, such that the later mark is declared void ab initio, there will never have been any later mark at all for any other person to have made use of. Pausing there is no registration. But he doesn't have a time machine. The mark is still being used in the market. There is use that could be objected to, and no objection has been taken. It's entirely artificial. So that in some way, the use by a defendant has become unobjectionable because the mark has been invalidated. Ab initio. The use is what causes harm. And so it's on that basis, Fenn to distinguish between those 2 points. He says, I find it impossible fairly to characterise such an existential form of attack as amounting to acquiescence. But he's quite right to say it doesn't amount to acquiescence in the registration of the mark. But it does amount to acquiescence in the use of the mark. And it is precisely the kind of passivity the CJEU identified in Budvar, we say. So, having done that, we say that those matters don't really assist the judge. If I can just get to the end of this point before we come to the end. He takes further comfort at 193 from my Lord Justice Arnold's analysis in W3.
Yeah, well, you say the mistake there is to treat the recital of submissions as an acceptance of those submissions.
My Lord, precisely. My Lord, precisely. Again, that doesn't assess. So, the 2 points that my learned friend relies on in response on this is first, he refers to paragraph 58 and 59 of high-tech, which we've looked at. And in my submission, that doesn't assist him, and I'll respond further when my learned friend expands his point, but I'll deal with that in reply, if I may. And then his second point in response is that in EU IPO, bringing administrative proceedings within a 5-year period avoids acquiescence. But that, again, with respect to my learned friend, is to confuse the bringing of invalidity proceedings before the time bar with stopping the acquiescence period. In EU IPO, all they're concerned with is the proceedings that have been brought in front of them. And if you've brought it within the 5-year period, then acquiescence falls away. The relevant date concluding whether acquiescence has taken place is the date on which the proceedings have been brought in EU IPO, because then one looks backwards and says, well, have you acquiesced for 5 years before then? And so his reference to EU IPO really takes matters no further. Now, my lords, my lady, it's by my watch a few minutes past 1, and I have taken enough of your time this morning.
We'll break there. You've got quite a lot to do in 3/4 of an hour.
I do. I shall pick up. But I will attempt to trim my note. But I mean, my lord, it's a problem of my own making for taking too long in